Speaker, that the time is not enough. The Commission wrote to our President and sought for answers, and I'm seeking to give you those answers. But if you think we should stick to your 3 minutes, I have no choice. Going forward, next time I would like you as a Commission to understand that it doesn't make sense for someone to fly 3,000 miles, spend 3 days on a plane to come here and speak for 3 minutes. Thank you very much.
Your Excellency, you have 2 more minutes to conclude.
To address the urgent letter of appeal addressed to His Excellency, the President of the Republic of Uganda, issues concerning our country which were raised during discussions. The Government of Uganda acknowledges receipt of a joint letter of urgent appeal that was written to His Excellency, the President of the Republic of Uganda, regarding reports of alleged violations of the independence and security of legal professionals, particularly the purported arbitrary arrest, detention, and sentencing of Advocate Eron Kiza. Honorable Chair and members of the Commission, the Government of Uganda wishes to respond to the above concerns as follows. Uganda is a constitutional democracy and a country governed by laws. Chapter 4 of our Constitution contains the Bill of Rights and provides for the protection and promotion of fundamental and other human rights and freedoms. Article 23 of the Constitution provides for the protection of persons' liberty and provides permissible circumstances under which the right to liberty can be interfered with, one of them being in execution of a sentence or order of court. The laws of Uganda guarantee access to justice for any person who alleges a violation of their human rights, including arbitrary deprivation of liberty, to apply to court for a writ of habeas corpus and approach other government institutions for redress. During the trial of Dr. Kiza Besigye in the General Court Martial, Advocate Eron Kiza's conduct was deemed contemptuous, and as a result, he was convicted of the offense of contempt of court and given a custodial sentence. Eron Kiza then applied for a writ of habeas corpus under High Court Miscellaneous Clause number 37 of 2025. On the 3rd of March 2025, the High Court heard and determined the application and held that the procedure adopted by the applicant to challenge the impugned conviction and sentence was incorrect and was an incorrect one, and therefore the court dismissed his application. He was later released from detention on bail pending determination of his appeal. Honorable Chair and members of the Commission, it is important to note that the Constitution of the Republic of Uganda recognizes contempt of court as an offense which the court-martial had every right to determine until the Supreme Court ordered otherwise. The sentence of contempt of court need not be overemphasized, as it ensures decorum and proper conduct of judicial proceedings with candor and respect of all parties involved, as well as judicial officers. The hearing of Advocate Eron Kiza's application for habeas corpus before the civilian courts was in itself a display of the government's commitment to respect the Supreme Court decision on the trial of civilians before the General Court Martial. In the case of Attorney General versus Michael Kabaziguka, Constitutional Appeal number 2 of 2021, the Court of the court held that courts martial are not independent and impartial courts that can guarantee a right to a fair hearing envisaged under Article 28 of the Constitution. Mr. Eron Kiza rightly exercised his right to a fair hearing before an independent and impartial court or tribunal. Article 28 of the Constitution guarantees this right, which includes the presumption of innocence, right to be informed promptly, right to police bond, right to apply for bail, right to be tried without undue delay, and access to legal representation. The right to a fair hearing is non-derogable under Article 44 of the Constitution. The government does not, therefore, condone the violation.
Monsieur le ministre, nous courons après le temps. Est-ce que vous, étant donné que nous aurons déjà ce texte-là, on a compris que le cas a été pris en charge par le gouvernement, s'il sera possible que vous concluiez afin de permettre aussi à d'autres délégations de prendre la parole. Parce que la déclaration, là, nous allons l'avoir. Nous allons l'avoir, bien évidemment. Si nous vous prions de conclure pour nous permettre de prendre aussi d'autres délégations.
So that to enable us to take other declarations, time is of the essence. That statement will be submitted to us by the Secretariat, and we'll get into all the details. Thank you very much.
That the time is not enough. The Commission wrote to our President and sought for answers, and I'm seeking to give you those answers. But if you think we should stick to your 3 minutes, I have no choice. Going forward, next time I would like you as a Commission to understand that it doesn't make sense for someone to fly 3,000 miles, spend 3 days on a plane to come here and speak for 3 minutes. Thank you very much.
Your Excellency, you have 2 more minutes to conclude your statement. I explained at the beginning that we have 1 hour for everybody. The list is quite long. I just wanted to humbly request you to skip spare us with some details and go to the gist of your statement, so that to enable us gain time. We are aware that everybody traveled and everybody deserves more time, but we also have working days that are limited to 8 hours. So we also have constraints. We'd like to apologize if that's how you feel, but please, you have 2 to 3 more minutes so that you can wrap up with your statement. You have the floor, sir.
Chair, for that reconsideration. I think on the matter of urgent concern for which you wrote to the President, I have made sufficient comment. We'll skip part of it. You will receive it in written text. There were other issues that were raised during discussion. Honorable Chair and members, there have been other issues raised on the floor regarding the alleged violation of rights of journalists and student demonstrators, the alleged violation of rights of women with disabilities, and transnational repression. The government of Uganda strongly believes that safety of journalists is essential to preserve the fundamental right to freedom of expression. The government has put in place effective laws and measures to establish a safe and enabling environment for journalists to work without fear of violence. These include the Press and Journalists Act, Chapter 100, which establishes the Media Council that is mandated to regulate the conduct of journalists, arbitrate disputes between public and the media, and the state and the media. Additionally, Uganda has continued to hold accountable any public officer who violates rights of journalists in the practice of their profession. The government of Uganda requests the Commission to take interest and work together with member states to develop strategies to curb growing concerns on the misuse of social media. In relation to the issue of student demonstrators, the government of Uganda acted on intelligence reports to proactively prevent any situation of violence that may affect the safety of students and the peace and security of the country, which are target of terrorists and potential conflict. The government of Uganda has ensured the representation of women with disabilities at all levels of leadership, like Parliament and local councils. There is a special grant for persons with disabilities, the National Council for Persons with Disabilities, the National Persons with Disabilities Policy 2020, which creates awareness of the rights and legal guarantees for women and girls with disabilities in order to implement the Persons with Disabilities Act, Chapter 115. The Constitution of the Republic of Uganda is affirmative in favor of marginalized groups, including women and girls with disabilities. The government of Uganda has further exercised special treatment persons of with disabilities in the recruitment, procurement, and accessibility process. Therefore, protection of their rights as opposed to discrimination. Regarding the issue of international repression, the government of Uganda has established international cooperation with different countries, which include signing mutual legal assistance agreements and a framework of the treaty establishing the East African Community. These foster regional peace and security in handling cases across border. In conclusion, Chairperson and members of the Commission, while it was your concern that Advocate Eron Kiza's arrest, detention and conviction were considered arbitrary in nature, the government of Uganda maintains that the process was not arbitrary. His rights to a fair hearing, a fair trial with respect was respected, and although the application for the writ of habeas corpus was brought under a wrong procedure, he was subsequently granted bail. That notwithstanding, the government of Uganda has demonstrated to the Commission the country's commitment to uphold and protect the rights of its citizens enshrined in the Bill of Rights under Chapter 4 of the Constitution. Thank you.
The Commission would like to thank Honorable Kafuuzi for that reply and has taken note the request to submit this statement so that the various mechanisms can initiate actions in accordance with what is written in that statement, that speech. And the Ministry of Legal Affairs of the United Republic of Tanzania, the ministry is represented here by the legal counsel Ludugama. You also have the right to take the floor for your reply. Please endeavor to be brief, since time is of the essence.
I would like to address the specific issues raised, including alleged limitation of freedom of expression, targeting journalists, restriction on civil rights, such as arbitrary arrests and of opposition leaders.
Monsieur Zulu, les interprètes demandent